So in this case, so that was a unilateral conversion. Unilateral conversion never become the unilateral conversion. So his unilateral conversion actually violate the provision section 35, and his prior marriage didn't dissolve legally. So without dissolving his prior marriage, he uh, undergone a second marriage. So according to section 18, he his second marriage was invalid. Also, section 35, he has convicted bigamy. So this was what has decided in the case of Abhay Sundar versus Abhay Sundar. Right, this is about the marriage cases, and there's a board called quasi board. Quasi board is specially established for the Muslims couple. Actually, Muslims are not, it's me, in their religion, they are not permitted to formal courts to appear in the formal courts. And for that, especially, the quasi board has established for their regarding their matters. So, if any decision regarding the marriage or divorce or something, any matter regarding Muslims, if quasi board grant decision and the parties were not satisfied with the quasi board decisions, they can appeal that decision to Supreme Court. Right? Next. Also, regarding the we call that any claim of maintenance from father, or any claiming maintenance from husband to the wife, if any uh, maintenance should compensation should get from the husband or any party regarding Muslim matters, quasi board can send the request letter for MC court. It's mean magistrate court, right? Can send request letter to MC court to issue warrant regarding retaking maintenance. Next is another additional information about the marriage. There's a compensation we called kai kuli, right? Kai kuli is the fund or money which given by the parents to the bridegroom for the maintenance of their daughter, right? This is the contract, right? The marriage in Muslim was a contract. So the parents will give to the bridegroom to maintenance of the daughter, their daughter. That is we call kaikuli. And mahar, mahar is the also bridegroom, right? The husband or bridegroom give to the parents has a compensation of their wife to get the wife to marry their daughters. Bridegroom gives some sort of money or amount to the wife's parents. That is we call mahar. It is equal to the dowry. Then sadak. Sadak is the gift for the wife from husband. So there are three things: kaikuli, mahar, and sadak. Okay, then next, a different topic. This is also part of law of persons, adoption. In the adoption, a case regarding the adoption, I'm going to explain here. Gauss versus Gauss, 1986. Right? In this case, actually, what happened? We are going to explore the facts of this case. A Muslim parents or Muslim couples adopting a child, Muslim couples adopting the child from the Adoption of Children Ordinance number 24 of 1941. There is no special ordinance regarding the adoption of Muslim child or adoption of a child to a Muslim couple. There's no separate ordinance for Muslim people. The ordinance which govern under the general law, the Adoption of Children Ordinance number 24 of 1941 applies in every scenario. So here, the Muslim couple has adopted a child according to Adoption of Children Ordinance number 24 of 1941. And the question raised here, the legal issue was whether the adopted child, can be inherited by their adopted parents. We know inheritance is given by the generation to generation, right? So from father or mother, the born children will get the property of their parents. We know that inheritance. But in this situation, the child is not born to their really born to their parents, right? Muslim couple. That child was an adopted child. So the question raised here, whether can this adopted child, inherit from their Muslim adopted parents? Right? So here, we have to know that the inheritance will govern under the Muslim intestate succession ordinance. We know that, right? So, however, the inheritance will be governed under that ordinance. So, what is the judgment came here was, yes, of course, the adopted child also have rights on inherit the adopted parents' property, because Adoption of Children Ordinance give the rights to the adopted child to inherit from their adopted parents. As much in this Muslim around the Muslim people also, the adoption will be governed under the Adoption of Children Ordinance, which is general law. So according to that, rights will be provided to adopted child, and also that inheritance will be governed under Muslim Intestate Succession Ordinance 1931. Okay. Next is the divorce. Actually, in Muslim law, male can easily take the divorce from the wife, but wife cannot easily take divorce from husband. So male, if the husband pronounce talak for 3 times, it means the marriage was dissolved. It is terminated if he pronounced talak, right? But for the female, if she wants divorce, she need to prove the fault on the husband. What is the fault? So it's basically that divorce called as fasa divorce, right? So what are the ground for that divorce? Adultery, physical or emotional abuse, abandonment, cannot live together, these things. According to the FASA divorce, I'm telling. Not all around. I'm telling, according to FASA divorce, these are the grounds: adultery, physical or emotional abuse, abandonment, and can't live together. Abandonment means neglecting the partner, wife, or wife feeling loneliness, right? Another type of divorce is there, Carl divorce. Carl divorce means wife leave the husband. Carl divorce. It can be Carl divorce. There's some pronunciation for will be there. I'm sorry. Next, Mubarak divorce. Mubarak divorce means husband and wife mutually separating. Right? It's based on mutual consent. This is about the divorce. Right. Next, loss of property. Loss of person, it is on marriage, divorce, adoption, majority, and then guardianship. Loss of property, we are going to say first is intestate property. You know what is intestate property? Intestate property means there's no last will on the property of a dead person, right? Without the last will of the dead person, the property will be how the property will be shared, right? That is intestate property. So here the intestate property will decide as after all the cost of the death ceremony of the dead person, the remaining amount will taken as intestate property of that person, right? Here, that is the main point. After all the settlement of the death ceremony of the died person, that balance amount of the property will taken as intestate property. Then inherited property. In inherited property, you know what is inherited property? From the parents, children getting property. In inherited property, we are going to see a case, Bandirala versus Mariam Nachia, 1912. Bandirala versus Mariam Nachia, 1912. In this case, what happened? Actually, the daughter of a father, right? In Muslim daughters from father can get the property, actually, right? They can get property from the father, right? What amount they can get? Actually, in Mohammedan code, which is operated in Sri Lanka, it stated 3 out of 4 will inherit to the daughter, right? But in Islamic principles, 2 of 3 will inherit to daughter. But actually, what happened here? Islamic principle is not operating in Sri Lanka. Mohammedan code is operating in Sri Lanka. For that, 3 out of 4 portion of father's property will inherit to daughter. That is the decision which given by the court. That is regarding the inherited property. One of the case. Another case we had to see here, Tilaratna versus Samsidin 19. right? Or 19, it's been 1900 year. In this case, Thilaratana versus Samsidin, it actually is not regarding the inherited property, but I have to tell this regarding the property, laws of property, right? I like to tell this case in this moment. Thilaratana versus Samsidin, 19. In this case, married women, right, administering immovable property, right? The question raised whether a married woman cannot administer immovable property, right? What is the right on married women to administer immovable property? Actually, the Mohammedan code was silent in this particular matter, right? Mohammedan code was silent. So, we know there's the practice in Sri Lanka with whenever the special laws have gaps, lacuna, right? The Roman Dutch law, our general law, will used or fill the gaps of special laws. So here Roman Dutch law fill the gap of this, and in Roman Dutch law we know without husband consent, married women cannot administer any property or transfer something, right? So according to this case, Roman Dutch law fill the gap, and in Muslim law also, husband consent was needed for married women in mobile properties operation. So, because of Mohammedan code was silent in this particular matter, the Roman Dutch law was affecting the femisol of Muslim women, right? Femisol means the women can do according to their own will if they marry or not, right? That is femisol. So Roman Dutch law here affecting the femisol of Muslim women in Sri Lanka because the Mohammedan code was signed. Right. Next, donation or gifts. Right? This is not law of property. This is donation of gift, a separate topic. Right? Donation or gift in Muslim law, actually, Muslims can choose to whom property should handed over. They can choose. Actually, in Canadian law, definitely the parents' property should inherited to their children. That the property cannot go outside, right? If it is the last will or any written any gift or something can. But in Muslim law, that is not nothing like that. The Muslims can choose to whom their property should handed over, right? They can revoke their gifts. If gift provided to somebody, the donor can revoke anytime can he cancel the gift and retake it unless it's stated as irrevocable in the contract. Okay. Also, widow can accept gifts, right? Widow also can accept gifts in Muslim law. It's no problem if the widow wife getting gifts and all. And also in Sri Lanka, not in Islamic principle, in Sri Lankan Muslim law, cannot offer fideicommissum gifts, right? Fideicommissum meaning there's conditional gifts. In Sri Lanka, Muslims cannot offer conditional gifts. Okay, now we're going to see a case regarding fideicommissum gifts. The case was Khatija Umma versus Mira Lepe, 1930. Right? Khatija Umma versus Mira Lepe, 1903. In this case, actually, here the grandfather, the old man is the grandfather. Grandfather handed over his property to his son with a condition, fideicommiss. What is that condition? One of four of the property should, right? Quarter, it's mean the quarter. So one of four of the portion of property should inherited to an outside, not within the family, to an outsider. This one of four portion should go. Only 3 out of 4 portion can be enjoyed or inherited within the family or to the children. That is the fideicommissum or the condition which proposed here by the grandfather. According to that condition, the father, right, got his portion. So that was the last will of the grandfather. One of the 4 should go to the outsider. So according to that, father got the portion. Right? Now, the property of the father should inherited to their children. The father had 3 sons and a daughter. There are 4 children now to the father, 3 sons and a daughter. Now, according to this, the property of the father has divided to 4 parts and 3 parts have inherited to his son. Right? He has given his 3 out of 4 portions to his sons. And he refused to give the last part, 1 of 4, to the daughter, and he has gave it to an outside. Right? This is the conditional gift, which is the last will of grandfather. Now the father also followed it. Now father's last will also this particular condition, which is 3 of 4 should inherit to his son, not to the daughter. The 1 of 4 portion, the last portion, will inherit to an outside. Right? That's gift to the outside. So now the daughter, what she is doing, actually so against his father to the court with the reason of reivindication. 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 What is reivindication? Reivindication means actually filing the case regarding the property which is asking the property to separate again and get, right? Filing the case in the court to separate the property fairly to all the children. That is reivindicatio, meaning of that. So she filed a case in the court regarding the reason of reivindicatio, that the separation of the property of my father is not fair. So the court should fairly divide it and give. So she raised two questions: whether she enjoyed the last part, one of four, which is inherited outside to her, or else getting the property back, which is given to the three sons, and dividing that to fair four parts accordingly. That is her two questions, which is, I tell it again, whether to enjoy the last part of the portion to her, give that portion to her without giving it to the outsider, or retaking the property which given to the sons and dividing that to four and enjoying for these four people, four children, fairly. Now the court said, actually, uh, what the court said was, mm, so what happened here? So what happened here? So the court said, um, this the fideicommissum or the conditional gift is not used in Sri Lanka. It's not used in used in Sri Lankan Muslims, but has the last will of the father, it should consider with the Roman Dutch law. So in Roman Dutch law, there's fideicommissum, right? So Roman Dutch law has again filled the gaps in this. So according to the last will of the father, cannot do anything. The daughter should remain without the property, and sons has a father's will, they will inherit. At what happened in Khadija Umma versus Mira Lepe 93. Next, another case, Idrus Satok, Idrus Satok versus Siti Leudin. Idrus Satok versus Siti Leudin 1950. In this case, actually, in the case Idrus Satok versus Siti Leudin 1950, minus whether the minor children can take the gifts or accept gifts, right? Minor children, in this scenario also, the Mohammedan court was silent. So According to Roman Dutch law, minors cannot accept the gifts without the consent of adult. So adult consent should be there with the acceptance of gifts by minors. Next, another separate topic, not the donation of gift. In the donation gift or gifts, we studied a case called H.W.Tambiah versus Meena Lebde, right? The laws regarding the donations. Also, another case called Idris versus Siti Layuddin, 1950 case also. Now we are going to learn about Muslim trust or waqfs. Already I told what is waqfs, funds which used for moral things. Muslim trust mean actually use of funds. Our Muslim trust. What is use of funds? Use of funds mean collecting profit, administrating someone else's property with the consent of owner. That is use of trust. On with the consent of owner, collecting with the consent of owners, collecting the profits, also administrating the property of the owner. That is use of funds. And the waqfs, these two manage under the Muslim trust and waqfs. We know these two govern under the Act, Muslim Mosque and Charitable Trust, that is the use of funds, or Waqfs Act 1956. Right? Next, I like to explain you the contrast between Islamic principle and Mohammedan code. Already we studied some of the contraries. Now I like to give you with the table. In Islamic principle, gifts are irrevocable, right? In Islamic principle, gifts are irrevocable. But in Mohammedan code, gifts are revocable unless it's stated as irrevocable. Right? Also, regarding the gifts, in Mohammedan code, it's stated there should be evidence. In Sri Lankan code, there should be evidence for everything. So in Mohammedan code, also it's stated delivery possession is the evidence for the donee. Right? For the donee, delivery possession is the evidence. But in Islamic principle, there is no evidence called delivery possession. There's no need to keep the delivery possession has the evidence. Next, ground for divorce. In Islamic principle, there's a ground for divorce called leprosy. Leprosy also ground for divorce for the wife. What is leprosy? That is a skin disease. Kind of skin disease. If that disease has affected the husband affected by that disease, wife can get divorce. But in Mohammedan code, there are no principles like that. Only mutual consent, adultery, emotion, physical abuse, abandonment, don't live together. Be taken as the ground for divorce. Right? Next, the 2/3 of father's property will inherited to the daughter in Islamic principles. Already we learned that from the case of Bandilalu versus Mariam Nacho, 1912. And next, fideicommism is in Islamic principle, but in Mohammedan code, unless it was last will, other than that, it is not used in use. Right? This one we already learned in the case of Khatija Umar versus Mira Lebbe, 1903. And next, anti-nuptial contract is in Islamic principle, but not in Mohammedan code. What is anti-nuptial contract? Anti-nuptial contract is a contract which made before the marriage by the husband and wife, bridegroom and bride. Right? Before the marriage, husband and wife, when they about to get married, they signing a contract, what they're going to do and regarding property or anything else. That is anti-nuptial contract. So here now we are going to see a specific case in anti-nuptial contract. Abdul Rahman versus Ushan Umar, 1960. Abdul Rahman versus Ushan Umar, 1960. In this case, before the marriage of the husband and wife, they went into an anti-nuptial contract that it called the the properties which owned by the husband and wife after marriage also, they can operate their property separately without they no need the consent of the partners, right? And then if one of the partner has died, the properties should go to inherited to their children. That property cannot enjoyed by the partners. That the property should go to the children, but the partners can get some money regarding the maintenance. Okay? That is the antinuptial, the main clauses that stated in antinuptial contract of Abdul Rahman versus Ushan Umar, case 1960. So according to that, the husband and his first wife, who was in India, right, married with the antinuptial contract and had a daughter. Again, he came to Ceylon and he remarried another woman with same antinuptial contract and had 5 minor children. Right? Now the husband was dead. So the question raised to maintenance of the Ceylon tea estate property. Why it's called as tea estate? Because already the father said the property should go to their children. Right? So the property, the question raised on whether the property will go to the minors or to the defendants. Who are the defendants here? The first wife who lived in India and her daughter and daughter's husbands are defendant in this case because they said the tea estate can go to the minor children because they are minors, and the property, Ceylon tea estate property, should go to handed over to the first wife or the daughter, first daughter. not the wife, handed over to the daughter. That is the question they mentioned here. But court considered this issue that said there's no contract between the first wife and the second wife. The contract is between the antinuptial contract is between the husband and second wife, because the property is regarding the Ceylon tea estate property, not the properties in India. Also, anti-nuptial contract is not in operation in Sri Lanka. The Mohammedan code was silent. For that, again, Roman Dutch law filled the gaps used as residuary law. Said in Sri Lanka, Mohammedan code also said minor children cannot accept gifts or own property without the consent of adult. We know that already in Idris Satak versus Sitti Leudi, 1950, we learned that. So the property now, for instant, can go to the minors children. For that, the mother of the second wife of the husband will be to administer the Ceylon tea estate property until the 5 minor children become major. So, according to Roman Dutch law, that was decided again. So, next, another country I would like to explain you. Minor children have property right in Islamic principles, but in Mohammedan code, wife administer until become major. Already in this last case, Abdul Rahman versus Shan 1913, also we can say this specifically, right? Next, Ibrahim Saibu versus Umahadu 1898. Ibrahim Saibu versus Umahadu 1898. What they said actually regarding this country, minor child can have property right? So the widow wife can administer husband property. Roman Dutch law, again, it has applied here because the minor children cannot have property. So the widow wife can administer her husband property until the children become major. That is said in Ibrahim Saibu versus Mumahadu 1898. Next country, Banami transaction. It's a kind of contract transaction, business transaction in Islamic principle. In Islamic principle, Banami transaction is there, but in Mohammedan code, in Sri Lanka, there's no usage of Banami transaction. Another case I would like to explain you, that was Muttalibu versus Ahmed, 1915. Muttalibu versus Ahmed, 1915. It is regarding the Banami transaction. That case is regarding Banami transaction, Muttalibu versus Ahmed, 1915. What happened? In Islamic principle, Banami transaction was there, but in Mohammedan code, it was not. So, the court has again gave force to Mohammedan code, not to Islamic principle. In Sri Lanka, there's no Banami transaction. So in Mutlibos Ahmed case also, Banami transaction is not in usage in Sri Lanka. We have to follow Mohammedan code, not the Islamic principle. So that's all in Muslim law. So thank you for watching. I hope you'll understand and get some sort of idea in special law of Muslim law. So we'll meet again with another video.